Imagine you finally saved up enough to buy that dream plot of land in the Philippines.
Right.
You got the signed deed, the keys, you've shaken hands with the seller. So you're the owner now, right?
You would certainly think so.
Yeah, but actually, you might be standing on a legal landmine because that piece of paper in your hand isn't the magic moment.
It really isn't. The registration is what changes everything.
Exactly. So today, our exploration into the source material is unpacking the Philippine Torrens system. We're looking at a legal guide on subsequent registration and voluntary dealings.
And the goal here is to help everyone navigate things like the Mirror Doctrine, the difference between voluntary and involuntary dealings.
And how to make sure you actually qualify as an innocent purchaser for value, which is huge.
Yeah, it's a concept that catches a lot of people off guard. I mean, it feels totally counterintuitive.
Because in a lot of places, just handing over the land...
What lawyers call tradition. Yeah.
Right? Tradition. That's usually the big moment.
But under the Torrens system, that's just a side note, the real power is the operative act, which basically means the act of registration in the Register of Deeds is what actually binds the land.
So it transfers ownership to you right then.
Exactly. Until you register, your contract is just a private agreement. It doesn't even exist as far as the rest of the world is concerned.
Wow. So if I don't register it, someone else could just swoop in, register a different deal on that same land.
And you're completely out of luck.
That sounds like a terrifyingly high-stakes race to the courthouse.
It absolutely is a race. But the system is set up this way to make land liquid. You can buy and sell property without digging through a 50-year history of every single past owner.
Which brings us to the Mirror Doctrine.
Right. You look at the Torrens title and you see everything you need to know. If a debt or some hidden claim isn't written on that title, you aren't legally required to go looking for it. You just trust the mirror.
Okay, but let's be real here. Is that mirror always perfect? Because the sources mention that registration is a ministerial act.
Yes, that's a crucial point.
To me, that sounds like the clerk at the Register of Deeds is just a human rubber stamp. They aren't actually checking if the seller is a crook.
That's the exact danger. They aren't judges or lie detectors. Their job is to record the paperwork, not validate the underlying contract.
So if the contract I'm registering is completely void or forged...
The act of registration doesn't magically cure those flaws. It literally just records them.
And you have to be careful about which book you're registering in, right?
Oh, massive distinction there. You have Act 496, which is now PD 1529, for registered Torrens land, and then Act 3344 for unregistered land.
And if you mix them up...
If you register Torrens land under Act 3344 by mistake, the law treats it as if you never registered it at all.
That is a brutal clerical error. Let's pivot to the deals themselves.
Right.
The guide splits them into voluntary and involuntary.
Right.
So buying land, I assume that's voluntary.
Correct. Voluntary dealings are sales or mortgages where the owner cooperates, but the catch is the owner must surrender the owner's duplicate certificate.
If they won't give you that physical title, you're stuck.
Completely stuck. But involuntary dealings are different. Things like court-ordered attachments or auctions, those can be registered without the owner's consent.
Which naturally brings us to the notice of lis pendens. I see this in the material as a massive red flag.
It's literally a warning to the world. It means a suit is pending.
So if I see that stamp and buy the land anyway, I'm just gambling on a court's future judgment.
Exactly. If the person suing the seller wins, you lose the land. And you can't claim ignorance because the warning was right there on the title.
Speaking of losing land, the forgery aspect blew my mind. The guide says a forged deed can actually become the root of a valid title.
It does seem inherently unfair.
How did the law justify letting a victim of forgery lose their property?
It's a really harsh trade-off. The law basically decides that the stability of the entire registry system is more important than the rights of one defrauded individual.
So if a forger gets a title in their name, then sells it to me, and I'm an innocent purchaser for value.
Or IPV. Yes. You get to keep the land. The original owner just has to sue the forger for damages.
But I have to prove I'm an IPV.
Absolutely. You can't just close your eyes and hope for the best. You have to show you paid full price and had zero notice of any issues.
And the Mirror Doctrine has limits here too.
Yes. If you visit the land and see someone else living there, you can't just point at the clean title and walk away. You have a duty to inspect.
And for banks, that standard is even higher.
Much higher. Banks handle public interest, so they have to do full site inspections. They can't just trust the paper. They have to look at the dirt.
So in the end, it's not just a race to register. It's a race to do your homework.
Precisely. In a double sale situation, the one who registers in good faith first is almost always the winner.
It's a fascinating, if slightly stressful, system. This exploration really highlights that ownership in the Philippines is a highly proactive process.
You can't just buy and relax. You have to register and defend.
Before you head out to your next real estate meeting, here's a provocative thought to mull over.
Let's hear it.
Since registration is just a ministerial act and doesn't guarantee a contract's validity, what happens to your peace of mind if the mirror of the title is perfectly clear, but the very first contract in the chain was flawed from the start?
That is a tough one.
Does the system actually provide security, or just the illusion of it? Something to think about.
You know, buying a piece of land, it's so much more than just a transaction. For a lot of us, it's the foundation of a dream. But let's be honest, with that dream comes a whole lot of anxiety. I mean, you're making one of the biggest investments of your life, and you have to know absolutely 100% that it is yours. So let's dive into how the law actually gives you that peace of mind.
Okay, picture this. You've found the perfect spot, you've signed all the papers, and you're holding a deed of sale. That's it, right? You're the owner. Well, you might be surprised to find out that this piece of paper, it's really just the start of the journey. The real proof, the ultimate protection, comes from a system designed to make your ownership crystal clear to the entire world.
So here's our roadmap for this explainer. We're going to start with the promise that a land title holds. Then we'll get into a really core idea called the Mirror Doctrine. We'll meet the hero of this whole story, the innocent purchaser. And then we'll look at what happens when that mirror cracks. And finally, we'll wrap up with how you can protect your big investment.
So, what is it that actually turns a simple sale into legally rock-solid ownership? It's not just about having the title document itself. The real magic happens with the act of registering that title under what's called the Torrens System. That right there is the key step that makes your ownership official and binding on everyone. Now, the whole point of registration is actually simpler and way more powerful than you might think. It's not about the government giving your sale a stamp of approval or saying the contract is perfect. Nope. Its main job is to be a public announcement. It's basically you shouting from the rooftops to the entire world, "Hey everyone, this property, it's mine now."
And this quote from Justice Regala just nails it. Legally, that moment of registration is what truly transfers ownership in a way that affects everybody else. See, before that, your sale is just a private deal between you and the seller. But after registration, it becomes a public fact that's tied to the land itself. To make this whole system work, there's this really foundational idea that everyone relies on. It's called the Mirror Doctrine. And honestly, the name itself gives you the perfect mental picture of how it all works. The idea is just this simple. The certificate of title is supposed to be a perfect mirror. It should reflect the exact legal status of that property. If there's a mortgage on it, it's reflected on the title. If there's a lien, it's on there too. A buyer should be able to look at that one document and trust that what they see is the complete and accurate story, no hidden surprises. So how do things get reflected in that mirror? Well, it happens through registering different types of dealings, which usually fall into two big buckets. First, you've got voluntary dealings, like a sale, where the owner has to willingly participate. And then you've got involuntary dealings, like a court-ordered attachment, which can be registered even if the owner doesn't cooperate. The important thing is, both are designed to get recorded, keeping that mirror nice and up to date.
The entire Torrens system, with this whole mirror principle, it's all built to protect one specific person, the innocent purchaser for value. This is the legal status you want to have. This is the person the law really goes out of its way to defend.
Okay, so who is this person? Well, it's anyone who meets two key conditions. First, they buy the property without knowing or having any reason to know that someone else has some kind of hidden claim to it. And second, they actually pay a full and fair price. They're acting in good faith and they're trusting the system.
But, and this is a really crucial point, this innocent purchaser status isn't just handed to you. It's not automatic. If your ownership ever gets challenged in court, you can't just say, "Hey, I acted in good faith." The burden of proof is actually on you to show that you did your homework and had no reason to be suspicious. So how do you prove it? Well, generally speaking, the law says you've acted in good faith if you can check these three boxes. 1. Was the person selling you the property the same person whose name is on the title? 2. Were they physically in possession of the property? And 3. Were you, the buyer, totally unaware of any other claims? If you can say yes to all three, you've probably met the standard. All right, so we know the title is supposed to be this perfect mirror. But, in the real world, mirrors can get cracked. There are very specific situations where just looking at the title isn't enough, and the law actually expects you to dig a little deeper. Let's just state the general rule one more time,
because it really is the foundation of the whole system. In most situations, you are perfectly fine, perfectly safe, relying only on what the title says. The law doesn't expect you to be some kind of private investigator. But, of course, the answer to that question is a big yes. There are certain red flags that should immediately set off alarm bells for a buyer, telling them, whoa, hold on, I need to do a little more digging here. Ignoring these signs can cost you your protected status as an innocent purchaser. And these are the big red flags to watch out for. Is the seller not actually the registered owner? Is someone else living on the property? Does the title have something called a notice of lis pendens on it? That literally means there's a lawsuit pending that involves the land. Any of these should be your cue to stop and investigate. I love this quote. It's a really powerful way to think about this. Chief Justice Narvaza is basically saying that the land itself is like a public record. If you visit the property and see other people living there, that right there is a form of notice. Their presence is a manuscript that you are expected to read by asking questions. You can't just ignore them and later claim you only relied on the piece of paper. And a special note here on banks. Because they are in the business of handling the public's money, the courts hold them to a much higher standard. A bank can't just glance at a title before approving a mortgage. They're expected to do a full-blown inspection and investigation. If they don't, that's considered negligence. Okay, so we've gone through the theory and the exceptions. Now let's bring it all home. How does this all come together to actually protect you? What are the big takeaways for making sure your investment is safe and sound? So, let's think about the absolute nightmare scenario, a double sale. A shady owner sells the exact same piece of land to two different people. Who gets to keep it? The rule is crystal clear. Ownership goes to the person who, acting in good faith, is the first one to register the sale. This just hammers home again how critical registration is. Now, this next one is one of the most surprising parts of the law, and it might seem totally backward at first. A forged deed is technically worthless. It can't legally transfer a title. But if a forger somehow gets a new title issued in their name and then sells that property to an innocent purchaser who had no idea, the law will actually protect that innocent buyer. The system puts the reliability of the registered title first, all to protect people who act in good faith. So at the end of the day, what's the most important point? It's this. The law protects the innocent, but it does not protect the careless. The system is there to give you security, but it's no substitute for good old-fashioned common sense and due diligence. So check the title, visit the property, ask questions. Your own diligence is and always will be your single best protection. And that kind of leaves us with a big question for the future. As we move more and more towards digital titles and online real estate transactions, how are these principles going to adapt? What's it going to mean to read the manuscript of the earth when you can close a deal from halfway around the world? The tools are definitely going to change, but that fundamental need for diligence, that will almost certainly stay the same.
There is this almost universal dream that I think cuts across pretty much every culture and every generation.
Oh, absolutely.
It isn't just the American dream. It's really just the human dream, the dream of owning a piece of the earth.
Right, a physical piece of the planet.
Yeah, exactly. You work hard and you save up for 10 or 20 years.
Yeah.
And you finally buy a plot of land and you stand there. You look down at the dirt, the grass, maybe some trees.
It's yours.
Yeah, you think, this is mine. I can build a house right here. I can raise a family here and nobody can take this away from me. It feels very permanent. It feels physical.
It's a very primal desire, I think. Security, tangibility. We are terrestrial creatures, so we naturally want our own territory.
Right.
But here is the uncomfortable and frankly terrifying truth that we need to confront today for this deep dive. Land isn't actually dirt and grass and trees. Not in the eyes of the law, anyway.
And that's where this gets really scary for a lot of people.
Yeah.
Because in the modern world, land is paper.
Yes. Just paper.
And if you don't understand how that paper works, you can literally be standing on your property, having paid for it, having built a house on it, having lived there for a decade even, and still find out that you own absolutely nothing.
Precisely. You can hold a deed in your hand and you can have the keys to the front gate. But if you haven't navigated the invisible maze of what we call the Torrens system, that land might actually belong to someone else.
Wow.
Or worse, you might just be buying a massive lawsuit instead of a home.
Which is exactly what we are unpacking today. We are doing a deep dive into the legal machinery of land registration.
And we really want to stress that we aren't just talking about how to file a form at a government office.
No, definitely not. We're looking at the philosophical and legal battlefield of who actually owns the planet when things go completely wrong.
Right.
We're talking about forgeries, double sales, banks getting lazy, and this mythical legal character called the innocent purchaser for value.
It sounds a bit dense, I know. But the mission for this deep dive is very practical. We are looking at comprehensive reviews of land registration laws, specifically the Torrens System, Presidential Decree 1529, and some really fascinating Supreme Court rulings.
That's a lot of source material today.
It is, but we're going to use it to see how the system decides who wins and who loses. Because the system is actually designed to protect the integrity of the title, the paper itself, sometimes even at the expense of the person who actually bought the land and acted in total good faith.
Which is just wild to me. I have to admit, I was a little intimidated by the legal jargon and the sources at first. It seems totally counterintuitive that the paper would trump the reality of you standing on the land.
I promise we'll decode all that jargon today into a story about risk, trust, and verification.
Perfect. But before we get to the horror stories, and we really do have some good ones today, we have to start with the absolute basics. The registry.
Yes. Registration.
I think most people, myself included, assume that when you take a deed of sale to the Register of Deeds, the RD, and they accept it, that means the government is stamping it with their official approval. Like, yes, this sale is valid, we checked it, you're good to go.
That is the first and probably the most dangerous misconception you can have. If you take nothing else away from this deep dive today, take this. The act of registration is what the law calls a ministerial act.
Ministerial act. That sounds very bureaucratic. What does that actually mean for the listener?
It basically means the Register of Deeds is acting as a clerk in this context. Their job is not to judge the validity of your deal.
Really?
Really. Their job is just to record the instrument. If you bring them a deed of sale and it fits the formatting requirements, like the margins are correct, the notary seal is there, the fees are paid, they just enter it into the book.
So they aren't checking if the deal is real?
No. They are not judges. They are not private investigators. They absolutely do not validate the contract.
Okay, so let's push this to the extreme just to be clear. If I decide to sell you the Brooklyn Bridge, or let's say the Rizal Monument, and we write up a very official-looking deed, and I take it to the Register of Deeds.
If you managed to present a title that looked like it covered that land, they would record it.
Wow.
The point is that registration doesn't miraculously make an invalid contract valid. It is, as the sources explicitly say, a species of notice. Think of the registry not as a validation service, but as a giant public billboard.
A billboard. Okay, I like that analogy.
Yes. When you register a sale, you are effectively posting a notice on a giant public billboard that says to the whole world, hey, attention, I have bought this land.
Right.
But if the underlying sale was void, say you didn't actually own the land you just sold me, or you forged my signature to get it, putting it on the billboard doesn't fix the fraud. It just announces a void sale to the world.
I see. So it's literally just a record.
Yeah.
It's a megaphone.
Exactly.
But it's a megaphone you absolutely have to use, right? You can't just keep the deed under your mattress and call yourself the owner.
Well, you can, but you really, really shouldn't. And this brings us to a critical distinction that confuses a lot of first-time buyers. The difference between binding the parties and binding the land.
Okay, let's unpack that.
Yeah.
Because when I sign a contract with you, I definitely feel like I'm bound.
And you are bound. Imagine you and I sign a deed of sale right now for a piece of land. I pay you $1 million and you sign the deed.
Done.
At that exact moment, the contract is valid between us. It binds the parties. If you try to back out tomorrow, I can sue you for specific performance. I own the land as far as you and I are concerned.
Okay, so I am the owner. I paid the money. I have the signed deed.
Between us, yes.
Mm-hmm.
But to the rest of the world, to a bank, to a brand new buyer who comes along, no, you are not the owner yet.
Wait, really?
Really? To bind the land, to make that ownership stick against the rest of the world, you must register it. Registration is the operative act that conveys the land to the public.
So if I don't register it, and you being a total jerk in this hypothetical scenario, decide to sell that exact same land to a guy named Steve.
And Steve goes to the Register of Deeds and registers it first.
Yeah.
Then Steve owns the land.
Just like that.
Just like that. Because as far as the world, and Steve knew, the land was still yours to sell. Your deed sitting under your mattress means absolutely nothing to Steve. The law protects Steve because he looked at the billboard and your notice wasn't there.
That is deeply anxiety-inducing. It means the race to the registry is actually a crucial part of the purchase process. You can't just relax on your couch until that stamp is on the paper.
Absolutely. Speed matters. But here's the thing. Accuracy matters even more. And here's where it gets highly technical. And I found this part of our source material fascinating. You can actually register it in the wrong book.
Ah, yes, the wrong drawer trap. was reading about this in the notes.
Yeah.
The distinction between the Torrens system and Act 3344, it feels like an absolute bureaucratic nightmare.
It is a nightmare, but it's a necessary one. In many jurisdictions, specifically looking at the Philippine context, which uses a very strict Torrens model, there are essentially two systems running in parallel. There is the Torrens system, which is governed by Presidential Decree 1529 for registered land, and then there's Act 3344 for unregistered land.
Unregistered land, that sounds a bit like the Wild West.
It's not quite the Wild West, but it's basically the waiting room. It's land that hasn't been brought into the formal Torrens system yet. Maybe it's ancestral land or land that just hasn't gone through the long court process to get a proper, guaranteed title.
Okay, so we have two drawers. Drawer A is for Torrens title land, which is the gold standard. Drawer B is for unregistered land, the waiting room.
Correct. Now here is the nightmare scenario straight from the case material. You buy a piece of land that actually has a Torrens title. It belongs in drawer A.
Right.
But for some reason, maybe your lawyer made a mistake or you were confused about the forms or the clerk was just having a terrible day. You register the sale under Act 3344. You put it in drawer B.
I still registered it. It's in the government office. I have a government stamp on my paperwork.
It is in the office, yes. But the Supreme Court has ruled that if land is registered under the Torrens system, but you record the transaction under Act 3344, it is considered not registered at all.
Whoa. Not registered at all, like zero effect.
Zero effect. It does not operate as constructive notice to the world. You basically put your billboard in the basement instead of out on the highway.
That seems incredibly harsh. I mean, you tried. You went to the office and paid the fees.
It is harsh, but the law values order above all else here. The Torrens system relies completely on everything being in the right place. If you allow people to file things wherever they want, the reliability of the entire title system collapses.
Could you give us a real-world example of this from the sources? Because I feel like if I were a buyer, I wouldn't have a clue which book is which.
Sure. There was a specific case mentioned in our review today, Mactan Cebu International Airport Authority versus Tirol. It's a classic example of this exact trap.
Okay, what happened?
A property was partitioned and sold. The buyers registered the sale under Act 3344, but the land actually had a Torrens title.
So they used the wrong drawer.
Exactly. Later on, the original owner sold it again to someone else. Let's call him Buyer 2. And Buyer 2 registered it correctly under the Torrens system.
And let me guess, Buyer 2 won.
Buyer 2 won. The court said the first sale was deemed not registered at all insofar as third parties were concerned. Buyer 2 had the right to rely on the clean title he saw in the correct registry. The first buyer's registration in the wrong book was completely invisible to him legally.
That is just heartbreaking for Buyer 1. They did the deal, they paid the money, they filed the paperwork, they just filed the wrong paperwork. It really emphasizes that you just can't wing it with real estate.
You really can't. And that brings us to the absolute superstar concept of this entire deep dive. The reason why we have this insanely strict system in the first place, it's called the Mirror Doctrine.
The Mirror Doctrine. I have to say, I love the name. It sounds almost mystical, like something out of a fantasy novel. Look into the mirror of title.
It is a bit mystical in a way because it asks you to believe in an illusion. The philosophy that holds the whole real estate economy together is very simple. A Torrens certificate of title is like a mirror. It should reflect the absolute truth of ownership.
So what you see is what you get.
Exactly.
That.
The rule is that a person dealing with registered land is not required to go beyond the four corners of the title.
The four corners.
Yes. You don't need to be a detective. You don't need to interview the seller's neighbors to ask if he's a trustworthy guy. You don't need to dig through dusty archives to see if the seller's grandfather really owned it back in 1920. If the title says John Doe is the owner and there are no annotations of mortgages or liens on the back, you can buy it from John Doe safely.
And this is primarily to facilitate commerce, right? Because if I had to do a full CSI investigation every single time I bought a house, the real estate market would just freeze up entirely.
Precisely. Imagine if every time you bought a plot of land, you had to hire a historian to trace the lineage all the way back to the Spanish era or the original land grant. Nobody would ever buy anything. The transaction cost would be astronomically high.
Right.
So the state steps in and says, look, we will guarantee this title. You just look at the paper. It creates immense liquidity in the market.
But, and here's the massive but, that drives all these terrifying lawsuits we're talking about. Mirrors can crack. What happens when the mirror lies?
Mm-hmm.
What if the title implies the seller owns it, but he actually stole it?
This is the forged deed Plot twist. And this is where you, the listener, really need to pay attention, because this is where the law makes a very, very controversial choice.
Okay, lay it out for us.
The general rule in law is straightforward. A forged deed is a nullity. It conveys absolutely nothing. If someone forges your signature to sell your house, that sale is void. It's like it never happened.
Oh, as it should be. I didn't sign it. I shouldn't lose my house just because someone is good with a pen.
However, there is a massive exception to this rule, and it forms the backbone of the Torrens system. It involves the innocent purchaser for value, or IPV.
Walk us through this. How can a forgery, which is a literal crime, create a valid title?
Let's use the famous case of Foulet versus Lagarde from our source documents. It's a perfect illustration of this. Imagine a fraudster. Let's call him Mr. Thief. Mr. Thief targets a beautiful property owned by a true owner. Mr. Thief forges a deed of sale, transferring the land from the true owner to himself, Mr. Thief.
Okay, so Mr. Thief takes this fake forged deed to the Register of Deeds.
Right. And remember what we said earlier, the RD is just performing a ministerial act. They see the deed, it looks official, the margins are right, so they cancel the true owner's title and they issue a brand new title in the name of Mr. Thief.
So now, officially, on the government records, Mr. Thief is the absolute owner.
Correct. The mirror now reflects Mr. Thief. Now, obviously, Mr. Thief doesn't move into the house. He knows he's sitting on a crime and the clock is ticking, so he immediately puts it on the market and sells the land to you, the host.
Okay, so I'm just a normal person looking for a house. I see the listing. I like it.
You check the title at the registry. The title says owner, Mr. Thief. It looks perfectly genuine. In fact, it is a genuine government document, even though it was obtained by fraud. There are no liens. It's totally clean. You pay Mr. Thief fair market value, and you register the sale.
And I have absolutely no idea he's a thief. I'm completely innocent in this. I just want a nice house.
You are an innocent purchaser for value. Later on, the true owner comes back from a long vacation or maybe wakes up from a coma and finds you living in his house. He sues to get it back. In court, he proves the forgery. He proves conclusively he never sold it to Mr. Thief. Who wins?
I mean, my gut immediately says the true owner has to win. It was stolen. The entire root of the transaction was a lie.
Your gut is moral, but the law is economic. The law says you win.
But it was a forgery.
Yes. But the forgery allowed Mr. Thief to get a title in his own name. Once the title was in his name, you, the innocent third party, had the right to rely on that clean title under the Mirror Doctrine. The court basically says that between two innocent parties, you and the original owner, the one whose loss preserves the integrity of the whole system, bears the loss.
Between two innocent parties, that is such a heavy phrase. Because the true owner is innocent and I am innocent. But the law has to pick one victim.
Exactly. And the law explicitly picks the original owner as the victim. Why? To protect the public trust in the piece of paper. If we allowed the true owner to take the land back from you, then no one could ever trust a title again.
Ever.
Right. Every single buyer would be terrified that a forgery happened 5 sales ago and they're about to lose their home. The chain of title would become a chain of anxiety.
So the root of a valid title can actually be a crime.
Yes. A fraudulent document can become the root of a valid title if it passes into the hands of an innocent purchaser for value. The curtain drops on the past. The law effectively washes the title clean once it hits an innocent buyer.
So the true owner is just out of luck completely.
They lose the land, period. Their only remedy is to sue Mr. Thief for damages. But usually by then, Mr. Thief is long gone or living in another country or completely bankrupt.
That is a terrifying thought for any property owner listening right now. It means your ownership is only as secure as the system's ability to spot a forgery, which we just established they aren't really designed to do at all.
It puts a massive premium on vigilance.
Yeah.
But it also puts a massive premium on being that innocent purchaser. Because this protection isn't automatic. You have to earn it.
Right. You can't just stand up in court and say, oops, I didn't know.
Yeah.
You have to actually fit the profile. So let's profile this person. Who exactly qualifies as an innocent purchaser for value?
An innocent purchaser for value is someone who meets 2 specific criteria. First, they buy the property without notice of any other claim or interest. They literally have no idea there's a problem. Second, and this is crucial, they pay a full and fair price.
Why does the price matter, though? If I happen to get a great deal on a house, does that make me guilty?
If you get too good of a deal, yes, it does. If a mansion worth $10 million is being sold to you for $1 million, the law assumes you knew something shady was going on. Good faith is a condition of the mind, sure, but it's proven by your outward actions. A highly suspicious price tag should trigger a suspicious mind.
Okay, so I pay full market price. I check the title. I don't know about any fraud. I'm good to go.
Usually. But here is a nuance that really trips people up, and it's a distinction that legal scholars love to obsess over. We just talked about the fool case where the thief already had the title in his own name.
Right. Mr. Thief was actually printed on the paper.
But what if the thief is just pretending to be the owner?
Wait, what's the difference?
There is a huge difference. Suppose the title is still in the name of the true owner. Let's call him Juan Cruz. Mr. Thief breaks into Juan Cruz's house and steals the physical title deed.
Okay.
He shows up to meet you, claiming, "Hi, I am Juan Cruz. He looks like a nice guy." He forges Juan Cruz's signature on the deed of sale to you right there on the table.
Okay, so the title I'm looking at says Juan Cruz, and the guy sitting across from me drinking coffee says he's Juan Cruz.
In this specific case, if you buy it, you are not protected.
Why not? I relied on the title. The title was clean.
You relied on the title, yes, but you also relied on the identity of the person standing in front of you. The Mirror Doctrine says you can trust the paper, but it absolutely does not excuse you from verifying the person. If the title is in the name of the true owner and you deal with an imposter, the law says you were negligent. You should have checked his ID. You should have verified he was who he said he was.
That is a subtle but incredibly critical distinction. But let me get this straight. If the title is already in the thief's name, I'm protected because the mirror shows the thief. But if the title is in the victim's name and the thief is just posing as them, I am not protected because the mirror shows the victim. And I failed to notice I wasn't actually talking to the victim.
Exactly. In the first scenario, the chain of title was broken before you got there. In the second scenario, the chain was broken at your link. And the law says if you are the one dealing with the imposter directly, you are in the best position to prevent the fraud. You could have asked for 2 forms of ID. You could have asked for a tax ID. Since you didn't, you bear the loss.
This is deep. It's like a really high-stakes game of legal hot potato. You do not want to be the one holding the potato when the music stops.
And you definitely don't want to be the one who failed to prove good faith. The burden of proof is key here. If the true owner sues, you have to prove you were an innocent purchaser. You can't just say, "I didn't know." You have to actively show you had no reason to suspect anything.
And this leads us to a section of the outline that I found really amusing, actually, but also kind of terrifying if you have a mortgage. The banks must count coconuts rule.
Yes, the Rural Bank of Sharia versus Yaqan case. This is an absolute classic in property law. This is where the Mirror Doctrine really starts to crack.
So we said earlier that regular people, you and me, don't need to look beyond the 4 corners of the title. We don't need to be private detectives. But banks, they play by very different rules.
Very different rules. The Supreme Court has repeatedly ruled that banks and financial institutions are affected with public interest. They handle other people's money. Therefore, they are held to a much higher standard of diligence. They cannot just look at the paper. They are not allowed to be armchair land buyers.
Tell us about the coconut trees in this case, because this image really stuck in my head.
So in this case, the Rural Bank of Sharia was granting a loan secured by a piece of land. The title presented to the bank looked perfectly clean. The bank, following standard procedure, sent an inspector out to the property.
Well, that sounds diligent. They actually went there in person.
You'd think so. But the inspector's report was, let's call it minimalist. The report basically just said, yes, there is land here. Yes, there are coconut trees on it. He physically counted the trees. But he found nobody there at the specific moment he visited. Maybe it was lunchtime. He didn't bother to ask any of the neighbors who owned the trees. He didn't ask who was harvesting the coconuts.
You just counted them. 1, 2, 3. Okay, looks like solid collateral.
Exactly. Later on, it turned out the land was actually in the possession of the Yaqan family, who had been living there and farming it for years. The title the bank relied on was dodgy. It was part of a messy ownership dispute. When the Yaqan family sued to stop the bank from foreclosing, the bank said, "Hey, we're an innocent mortgagee. We checked the title."
And what did the court say to that?
The court roasted them. They effectively said, you went to the land, you saw it was a working farm, and you didn't even ask who is the farmer. That is gross negligence. A bank has to do more than count trees. They have to verify ownership on the ground. Because they failed to investigate the actual possession, they were not in good faith. They lost the security entirely.
This brings up a phrase from the notes that I underlined 3 times because it sounds so poetic for a legal text. The earth is a universal manuscript.
It's beautiful, isn't it? It comes from the idea that the land itself tells a story. The paper title is one story. That's the story locked in the registry. But the physical reality, Who is plowing the field, who built the fence, whose laundry is hanging on the line, that is another story. That is the universal manuscript. And the law says you cannot close your eyes to the universal manuscript just because the paper story looks nice.
So let's apply this to a regular buyer, not a bank. If I go to buy a house and the seller says, here's a title, it's perfectly clean, but I drive by and I see a family having a barbecue in the front yard who definitely isn't the seller.
You are legally obligated to get out of your car, walk up to that grill, and ask, excuse me, by what right are you eating that barbecue on this land?
That's going to be a very awkward conversation.
Yeah.
Pass the ribs. And also, do you have a lease?
It's awkward, sure, but it saves you from losing your entire life savings. If you see a tenant, a squatter, or any occupant at all, and you don't investigate their rights, the law presumes you aren't in good faith. You are buying the land subject to whatever rights those people happen to have. You can't hide behind the Mirror Doctrine if the reality on the ground is screaming caution.
So possession is actually a form of notice. The people living on the land are a billboard too.
Absolutely. Possession is the oldest form of title. The paper system was invented to make things easier for trade, but it never fully erased the importance of actual physical possession.
What about that other warning flag we see, the lis pendens? I see this term all the time in real estate discussions.
Yes, Latin for suit pending. You will see this annotated on the back of a title sometime. It's a very stark warning.
Like a hazard sign on the highway.
It's a giant neon sign that says, this land is currently being fought over in court right now. If you buy land with a lis pendens annotation, you are gambling. You are essentially buying the result of that lawsuit.
So if the seller wins the lawsuit, I keep the land. But if the seller loses...
You lose the land. And you cannot claim to be an innocent purchaser because the warning was printed right there on the paper. You bought the risk. It's like buying a lottery ticket where you know the odds are 50-50.
Okay, so we've covered the massive risks of buying the imposters, the squatters, the lawsuits. Let's pivot and talk about the actual mechanics of how these deals get registered. Because there's a really interesting distinction in the sources between voluntary and involuntary dealings. And it seems to hinge on who holds the physical paper.
Right. This is technical, but highly practical. A voluntary dealing is a sale, a mortgage, a lease. It's something the registered owner actively wants to do. I want to sell you my house.
Okay.
To register a voluntary dealing, the law requires you to present the owner's duplicate certificate of title.
That's the copy the owner keeps, right? Of the blue paper.
Yes. In the Torrens system, the registry keeps the original, which stays locked in their vault, and the owner gets the owner's duplicate. If you want to sell your land, you must physically surrender that duplicate to the RD so they can stamp the sale on it. If you don't present the owner's duplicate, the RD cannot and will not register a voluntary sale.
Well, that makes total sense. It's a built-in security feature. You can't sell my land unless you somehow have my physical copy of the title. It prevents me from selling it to 10 different people easily.
Exactly. It prevents unauthorized sales. But what if you were being sued? What if you owe a ton of money to a credit card company and they sue you, they win, and the court orders your land to be seized to pay the debt? That is an involuntary dealing.
And obviously, I'm not going to willingly hand over my title to the guy suing me. I'm not going to say, here you go, take my house, have a nice day.
Right. The law knows you won't cooperate. You'll probably hide the title under the floorboards. So for involuntary dealings, like an attachment or a court order, the requirements are different. The person seizing the land does not need to present the owner's duplicate.
So how do they register it if they don't have the paper?
They just record the court order in the daybook or the entry book at the registry. That entry alone is enough to bind the land. It warns the world this land is under attack. Even if the physical title hiding in your house doesn't have the stamp yet, the daybook at the registry clearly says attachment. And that is enough to stop you from selling it to someone else.
So even if I'm holding my title super tight, refusing to give it up, the court can still basically tag my property remotely.
Yes, because otherwise debtors would just hide their titles and never ever pay their debts. The daybook is the legal loophole that allows justice to catch up with a hiding debtor.
There was a specific case about co-ownership here too, the Balbin case. This sounded like an absolute nightmare scenario for families. What happens if there are multiple owners? Say 3 siblings own a single lot. Do they all have a copy of the title?
Usually there is just one owner's duplicate that they share, but sometimes co-owners can request separate copies for themselves. The Balbin case dealt with a situation where there were indeed multiple copies floating around.
And what was the core issue there?
The issue was someone trying to register a transaction with just one of the copies. One sibling wanted to do something, presented his copy, but the other siblings didn't present theirs. The legal argument was, do we really need to gather all the copies to stamp them all?
And the verdict from the court?
The verdict was yes, you need all of them. The law assumes all copies are identical. But in Balbin, there was a massive concern that if you annotate a sale on one copy but not the others, you create complete chaos. Imagine Brother A's title says sold and Brother B's title says clear. The mirror is broken.
So if you're buying land from co-owners, you need to make absolutely sure you get every single copy of the title that exists.
Correct. If they say, oh, my sister has a copy, but she's in Canada right now, just use mine, do not proceed. You need all the copies to ensure the registration is actually valid.
Speaking of messy situations, let's get to the ultimate nightmare, the one that law students probably lose sleep over, the double sale.
Ah, the double sale, the classic law school exam question, and sadly a surprisingly common reality.
So here is the scenario for you listening. A landowner, let's call him Scammer Sam, sells a piece of land to buyer A. Buyer A pays him, shakes hands, takes the deed. Then Scammer Sam waits a week, finds buyer B, and sells the exact same piece of land to buyer B. He takes buyer B's money too. Then Sam disappears to the Bahamas.
Right, so now we have buyer A and buyer B, both paid good money, both have a signed deed, both are totally innocent victims of Sam. Who gets the land?
It feels intuitively like it should be buyer A, right? He was there first.
Not necessarily. There is a very specific hierarchy of rules here, established by the Civil Code, Article 1544, and reinforced by the Torrens System. It is literally a race.
Race to where?
Priority rule number 1. The first to register in good faith wins.
Okay, so if buyer B, the second guy, gets to the register of deeds first.
Buyer B wins the land, even though he bought it later in time. If he registers first, he secures the property. Buyer A is left with nothing but a piece of paper and a long lawsuit against Sam.
That is brutal.
Yeah.
It's strictly first come, first served at the government office.
With one major caveat, good faith.
There's that phrase again.
If buyer B races to the registry, but he knows about buyer A, maybe he heard Sam brag about selling it twice at a bar, or maybe buyer A actually told him, then buyer B is in bad faith. His registration is totally void. The law says knowledge of the first sale is equivalent to registration.
So if I know you bought it, I can't try to beat you to the registry. My knowledge acts as your registration.
Exactly. But if buyer B truly doesn't know, buyer B wins.
Okay, what if nobody registers? What if both buyer A and buyer B are just lazy and leave the deeds on their desks?
Then we move down to priority rule number 2, the first to possess in good faith. If neither registers, whoever physically moves onto the land first wins.
Possession, like putting a fence up.
Putting a fence up, planting crops, building a shack. Possession is 9/10 of the law only if nobody bothered to register.
And if nobody registers and nobody moves in.
Then we finally go to priority rule number 3, the one with the oldest title date, basically the first buyer. Buyer A wins by default.
So the absolute moral of the story here is register immediately. Do not wait. Do not go get lunch to celebrate. Go directly to the RD.
Absolutely. The moment you sign that deed, run, don't walk to the registry. Because every single minute you wait is a minute where the seller could sell it again, or a creditor could attach it, or a random lien could appear. You are in a literal race against the world until that stamp is on the paper.
But wait, there is an even stranger version of this in the notes. We talked about double sales, but there is also a case of double titles.
Yes. DBP versus Mangoang. This is where the government really messes up. This isn't a scammer selling twice. This is the state issuing 2 birth certificates for the same child, essentially.
How does that even happen?
Usually a bureaucratic error. Maybe one title was issued as a homestead patent way back in 1920. Then 30 years later, a completely different government agency issues a cadastral title for the exact same land to someone else. Different maps, different surveys, but the exact same dirt.
So now you have person X with a valid government title and person Y with a valid government title. Both valid on their face, both covering the same plot. Who wins that fight?
The rule here is strict and somewhat metaphysical. Prior tempore, poacher jur, first in time, stronger in right.
So the older title just wins.
Yes, and here's why. The logic is that once the state issues a title to person X in 1920, the land essentially leaves the public domain. It becomes private property. The state no longer owns it at all. So when the state tries to give a title to person Y in 1950, they are giving away something they literally don't have. They are selling the Brooklyn Bridge.
So the second title is just void.
Void ab initio, void from the very beginning. It's basically a legal hallucination.
Even if person Y is an innocent purchaser. Even if person Y checked the mirror and it looked perfect?
Yes. In this specific case of double original titles, the Mirror Doctrine cannot save person Y because the mirror itself was a fundamental lie. The state cannot grant what it does not own. Person Y loses everything, even if they were perfectly diligent.
That is devastating. It means there is a tiny non-zero chance that even if you do everything perfectly right, a title from 1915 could surface out of nowhere and wipe you out.
It is a risk, a small one, but a very real one. It reminds us that the system is not perfect. It's just the best system we have right now.
So let's zoom out a bit. We have covered a massive amount of ground here today. We went from the ministerial act that the government just stamping the paper without checking to the Mirror Doctrine, where we are forced to trust the paper blindly. We saw the exceptions. Forgeries that magically become valid to protect innocent buyers. Banks that lose out because they didn't count coconuts properly. And the ruthless race of the double sale.
It's a highly complex ecosystem. It really is a jungle made of paper.
If you had to summarize...
Exactly. But for the listener, the highly practical lesson is diligence. The Mirror Doctrine is a great shield, but do not trust it blindly. If you are buying, go to the land. Talk to the neighbors. Check the chain of title. Make sure the person selling it to you is actually the person on the paper. And if you are already an owner, guard your title, keep your taxes paid, visit your land regularly.
Visit your land. That's a really good one. Don't just be a paper owner.
Right. Adverse possession and fraudsters absolutely thrive on absentee owners who assume the paper in their drawer is enough. The paper is powerful, but reality, actual physical possession, can sometimes undermine it if you aren't looking.
It really makes you think about the absolute fragility of ownership. We think of property as this massive, solid thing, but it's really just a consensus. It's just a legal agreement that we all promise to respect.
And that agreement relies entirely on vigilance. There is a famous maxim in law. The law helps the vigilant, not those who sleep on their rights.
The law rewards the awake. I really like that. Here's a final thought for you to chew on, something that wasn't explicitly in the cases we covered, but feels like the ghost haunting this whole discussion. We talked about how the law sacrifices the original owner to protect the innocent purchaser in a forgery case. It feels wrong, morally. The thief stole it, and the law just lets the new guy keep it.
It does feel morally sticky. It feels almost like legalizing theft.
But imagine the alternative. Imagine a world where you could buy a house, live in it for 20 years, raise your kids there, and then someone knocks on the door and says, hey, in 1975, this deed was forged, get out. If we didn't have this harsh rule, nobody would ever truly own anything, because the past could always come back to haunt the present. So is this injustice actually the price we pay for civilization? Is the universal dream of ownership only possible because we agree to ignore the crimes of the past once the title is washed?
That is the ultimate tension right there. Certainty versus equity. And in land law, certainty almost always wears the crown. We choose a system that works for the 99% of transactions, even if it completely crushes the 1% who get caught in the fraud.
A fascinating, if slightly terrifying, deep dive today. I'm definitely going to double check my own paperwork when I get home.
And maybe count the coconuts in your backyard too, just to be safe.
I will do that. Until next time, keep your eyes on the paper, but keep your feet on the ground. Thanks for joining us for this deep dive.
Welcome to the debate. Today, we are stepping into an arena that affects literally everyone. Whether you own a sprawling estate, a modest condo, or, are just dreaming of buying a plot of land someday. We are dissecting the Torrens System of Land Registration.
Right, and it's a high-stakes world.
It really is. The central question we are wrestling with today is fundamental to the stability of our entire economy. Is a certificate of title an absolute, impregnable fortress of ownership? Or is it merely a piece of paper that crumples when it hits the messy, tangible reality of the ground?
It's a fascinating tension because it pits two massive legal concepts against each other. On one side, you have the Mirror Doctrine, this idea that the government registry reflects the absolute truth, and you don't need to look any further. And on the other side, you have the duty of good faith and diligence, which suggests that if you blindly trust a piece of paper while ignoring, say, the people actually living on the land, you're not an innocent buyer, you're negligent.
Exactly. And we are grounding this discussion in the source material, specifically the Property Registration Decree, technically Presidential Decree 1529, as well as the Old Land Registration Act, Act 496, plus a whole labyrinth of Philippine Supreme Court decisions that try to balance these competing interests. I'll be taking the side of the public record. I argue for the sanctity of the registry, because for a modern economy to function, we must be able to trust the face of the title. If we can't trust the registry, we can't trade land.
And I come at it from a completely different angle. I'll be arguing for the necessity of actual diligence. Registration is a powerful tool, absolutely, but it does not validate a void instrument, nor does it protect a buyer who chooses to close their eyes to the reality of the physical world. The map, essentially, is not the territory.
All right, well, let's get right into the bedrock of my argument. My position is anchored in the stability of the system, specifically what we call the operative act. Under sections 51 and 52 of PD 1529, the law is completely explicit. A contract between a buyer and a seller, like a deed of sale, is just a private agreement.
Right.
It binds them, sure, but it does not effectively convey the land insofar as third persons are concerned until that document is registered. Registration is the operative act. It's the switch that turns the lights on.
I see why you emphasize the statute, and I don't dispute that registration is the mechanism. But let's be precise about what that switch actually does. You seem to imply that flipping the switch just fixes everything.
In many ways, it does. It serves as constructive notice to the whole world. I'm relying on the ruling in Gatan v. Gapet here. The Supreme Court was very clear. There is a presumption that a purchaser has examined every instrument of record. And here is the kicker. That presumption is irrefutable.
Irrefutable on paper.
Irrefutable in court. You cannot go to a judge and say, "Oh, I didn't know about that mortgage because I didn't check the registry." The law presumes you check. This is the Mirror Doctrine. The title is a mirror reflecting the true status of the land. If the mirror is clean, the buyer is safe.
That's the letter of the law, certainly. But let me tell you why I just don't buy that it's that simple. You were talking about the mechanics of registration, whereas I am talking about the validity of the transaction itself. The source material is very specific here. Registration is a ministerial act. It creates a record, yes, but it is not a declaration by the state that the instrument is valid. If I forge a deed and register it, the registration doesn't magically make the forgery real.
Well, we will get to forgery in a moment because there is actually a massive exception there that proves my point. But first, I want to address your skepticism about the mirror itself. If we required every buyer to go on a treasure hunt for hidden defects that aren't on the title, the efficacy of the Torrens system would be, to quote Justice Regala, futile and nugatory. It would be useless. We need the presumption that the record is correct, or else commerce simply stops.
Commerce might slow down, but justice would speed up. My main contention is about the definition of an innocent purchaser for value, or IPV. This isn't just about paying the price or checking the registry. Good faith is a state of mind. It's an honest intention.
Which is proven by relying on the official record.
Not always. You cannot claim to be an innocent purchaser if you close your eyes to known facts. If you buy a property and there is someone living there who isn't the seller, maybe a tenant, maybe an adverse claimant, and you don't ask, who are you and why are you here? You are not in good faith. Actual knowledge of a defect is equivalent to registration. You can't hide behind the Mirror Doctrine when the reality is staring you right in the face.
I see where you're going with that. And it touches on the nuances of diligence. But before we get into the street-level reality, let's stick to the registry-level risks. Because even the act of registration has traps that support my view on the supremacy of the system. If you don't follow the rules of the registry, you lose. Let's talk about the wrong book scenario.
You're referring to the distinction between Act 496, the Torrens System, and Act 3344.
Exactly. This is a technicality that has destroyed people's life savings. In the Philippines, we essentially have two registries. One for registered land, which are the Torrens titles, and one for unregistered land. If you have a Torrens title, you absolutely must register the sale under the property registration decree.
That seems straightforward enough. Follow the instructions.
You'd be surprised. There are cases where a sale of titled land was registered under Act 3344, which is the system for unregistered land. Maybe the lawyer made a mistake, or maybe the clerk filed it wrong, but the Supreme Court has been ruthless about this. If you register a sale of titled land in the wrong book,
It is legally meaningless. It does not operate as constructive notice to the world. It is deemed not registered at all.
Which perfectly highlights the vulnerability I'm so worried about. You could have a buyer acting in total good faith, paying their taxes, doing everything right morally, but because they filed the paper in the unregistered land book instead of the registered land book, they lose against a third party with a better right. The act of registration is highly technical and utterly unforgiving.
But that proves my point. The system demands precision because the record must be accurate. If we allowed filings in random registries to count, we'd have absolute chaos. The mirror only works if everyone is looking at the same mirror. If you stick your notice in a drawer in the basement, which is effectively what Act 3344 is for titled land, you haven't notified anyone.
I agree on the procedure, but let's look at where the Mirror Doctrine really gets tested, and where I think your argument for the sanctity of the title becomes morally questionable. Forgery.
I knew we were heading here.
It's the elephant in the room. Generally, a forged deed is a nullity. It conveys no title. You cannot acquire rights from a thief. If a person impersonates the owner and sells the land, that deed is void. Nemo dat quod non habet. You cannot give what you do not have.
That is the general rule, yes. But you're ignoring the chain of title doctrine, specifically the exception laid out in Fillet versus Delegar and Cruz versus Court of Appeals. This is actually the strongest argument for the Mirror Doctrine because it prioritizes the innocent third party over the original owner.
Walk us through that, because it sounds incredibly harsh.
It is harsh, but it's necessary. Suppose a forger transfers the title into their own name first. So the registry now officially says, Owner, Mr. Forger. It's a clean title on its face. If Mr. Forger then sells that land to an innocent purchaser for value, that innocent purchaser wins. They get to keep the land.
Even though the land was outright stolen from the original owner?
Yes, because the innocent purchaser didn't rely on the forger's word. They relied on the clean title issued by the Register of Deeds. If we didn't protect that innocent buyer, public confidence would just collapse. Every time you bought land, you'd have to worry, was there a fraud in 1985 that I don't know about? The Torrens system guarantees the current certificate, not the history of the universe.
I understand the logic of market stability, but it seems incredibly unfair to the original owner who was a victim of fraud.
The remedy for the defrauded party is to sue the forger for damages or claim from the assurance fund. But the land stays with the one who relied on the mirror.
That's a compelling argument for stability, I admit. But have you considered the state of mind again? That exception you love, the fuel doctrine, only applies if the buyer had absolutely no reason to suspect the fraud. The source material mentions Itagaud versus Court of Appeals. If a purchaser neglects to make necessary inquiries or closes their eyes to facts that should put a reasonable person on guard, they are not innocent.
I would frame it differently. I'd say that unless there is a glaring cloud or vice on the title itself, the duty to investigate is minimal.
Minimal? I strongly disagree with that. And this brings us to a specific group where the Supreme Court has smashed that minimal standard to pieces. The banks.
Ah, you're referring to Rural Bank of Sariaya v. Yacon.
It's the perfect example of why the Mirror Doctrine fails in the real world. In that case, the Supreme Court took judicial notice that it is standard practice for banks to inspect the land before approving a loan. In Sariaya, the bank inspector actually went to the land.
So they did their duty.
Hardly. The inspector went to the farm, found nobody there, and essentially just counted the coconut trees.
He counted the inventory but ignored the ownership.
Exactly. He counted the trees but didn't bother to ask who owned them or who was in possession. It turned out the mortgagor, the guy borrowing the money, never even took possession. There were other people working the land who had a better right. The court ruled the bank was negligent. They couldn't hide behind the clean title because their business is affected with public interest. They have a higher duty of diligence.
I concede that banks are held to a higher standard. They have the resources and the mandate to do so. But for the average private buyer, the four corners of the title are usually the limit of their responsibility. You can't expect a regular person to act like a corporate bank inspector.
I'm not convinced by that line of reasoning, mostly because of Francisco versus Court of Appeals. The court used a phrase there that I think is the absolute heart of my argument. The earth is a universal manuscript, open to the eyes of all.
It is a poetic phrase, I'll give you that. But what is the legal implication?
The implication is that the land itself is a document you have to read. If you buy land, you must look and see who is on it. If there are occupants other than the seller, you must investigate. You have to go knock on the door. If you don't, and it turns out those occupants have a superior right, you lose. You are considered a buyer in bad faith. The Mirror Doctrine just shatters if you ignore the reality of possession.
I accept that visible possession triggers a duty. If you see a house, you have to ask. But let's be careful not to overstate it. Mere possession by a third party doesn't automatically render the title defective. The source material clarifies that the possession must be of a character that asserts a superior right. If the occupants are just tenants or squatters without a claim to ownership, the title holder still prevails.
True, but the burden of proof shifts. If you claim to be an innocent purchaser for value, the onus probandi is on you to prove it. You can't just waive the title and say, I didn't know. You have to prove you exercise the measure of precaution required of a prudent person.
Let's shift to a scenario that really tests the mechanics of the system versus the good faith of the parties. Double sales. The case of DBP v. Mangawang paints a pretty chaotic picture.
Chaos is definitely the right word. In that case, you had one person, Amposa, who managed to get two different titles for the exact same land, one under the Homestead Law and one under the Cadastral Act. And he sold the land to two different people.
An absolute nightmare. But the resolution was actually quite structured. You might focus on the confusion, but the law looks at priority. Who registered first?
Well, in Mangawang, the court looked at who registered in good faith.
Correct. The general rule in a double sale under Article 1544 of the Civil Code is priority in time of registration. The first to register in good faith wins. In Mangawang, the first buyer registered years before the second, so logically, the second buyer bought nothing.
Right, because the seller had nothing left to sell. But the conflict arises, and this is the race aspect, when the first buyer registers in bad faith knowing there's a second buyer or vice versa.
Right.
If I know you bought the land yesterday and I run to the registry today to register myself first, I am acting in bad faith. My registration doesn't cure that. The system protects the innocent purchaser, not just the fast purchaser.
I agree with that, but notice that the solution still comes back to the registry. The court had to determine which title was validly issued and which registration took precedence. Even in the chaos of double sales, the registry is the scorecard we must use to determine the winner. We aren't abandoning the system, we are policing it.
But there is a huge vulnerability in how those scores are kept, particularly regarding the difference between voluntary and involuntary dealings. This is a technical nuance, but it's where a lot of people get blindsided.
I see this as a feature, not a bug. Let's clarify this for the listeners. In voluntary dealings like a standard sale or mortgage, the law requires the presentation of the owner's duplicate certificate of title. You need the physical, usually blue copy that the owner holds. This is a massive safeguard against fraud. You can't just walk into the registry and sell someone else's land. You need their copy of the title to do it.
That protects the owner in a sale, sure. But what about involuntary dealings? Attachments, court orders, levies?
In those cases, the owner's cooperation isn't needed. That's the very nature of an involuntary dealing. If I sue you and win, and the court attaches your property, you are going to just hand me your title voluntarily. So the law allows the sheriff to register the lien without your cooperation.
Right. And that's the risk for a buyer. The law does not require the presentation of the owner's duplicate title for an involuntary attachment. A mere entry in the daybook, the primary logbook of the registry, is sufficient to bind the land.
But notice is sent, and the entry in the book is, again, constructive notice.
Theoretically. But think about the practical gap. A sheriff's attachment is entered in the daybook at 9 a.m. It might not be physically annotated on the back of the title for days or even weeks because of administrative lag.
Okay, I see the scenario you're setting up.
So at 10 a.m., a buyer looks at the owner's duplicate title. It looks totally clean, no annotations. They buy the land. but they are actually buying land that was attached 1 hour ago. The mirror of the title is lagging behind the reality of the daybook.
That is a fair point on the technical procedure, but the law has an answer for that. The daybook is part of the public record. If a buyer wants absolute certainty, they shouldn't just look at the title, they should check the daybook or the entry book at the Registry of Deeds.
That is an incredibly high bar for a regular person. You're essentially saying, don't trust the title, trust the logbook.
I'm saying trust the system. The system includes the daybook. It is designed to create a single, verifiable source of truth. Yes, there are edge cases. Yes, there are forgers. But without the operative act of registration, we are back to a system of secret liens and verbal contracts.
I'm not arguing for secret liens. I'm arguing that the source of truth is a combination of the paper record and the physical reality. You cannot govern land ownership solely from an air-conditioned office. You have to walk the ground.
And I maintain that if we force every buyer to be a private investigator, commerce slows to a halt. We need to be able to trust the seal of the government.
Trust, but verify.
A fair compromise.
Before we wrap up, I do want to touch on one last thing regarding lis pendens.
Pending suit.
Yes. If a notice of lis pendens is on the title, the Mirror Doctrine is absolute in the reverse. You are warned. You are buying a lawsuit.
Absolutely. A buyer takes the land subject to the outcome of the litigation. It is a warning to the whole world. In that case, the mirror is clearly showing a crack, and if you buy it, you buy the crack.
Exactly. And that supports my view that good faith is about knowledge. The lis pendens provides knowledge, but so does a squatter on the land. Both are warnings. One is written in ink, the other is written in reality. Both must be heeded. If the seller tells you, "Oh, don't worry about that lis pendens, the case is weak," and you believe them, you are not in good faith. You have to investigate the lawsuit itself.
We're nearing the end of our time, so let's try to synthesize this. We've covered a lot of ground today, from the property registration decree to the coconut trees of Sariaya.
Please, summarize the case for the registry.
The Torrens system is designed primarily for stability. While my colleague here has pointed out valid exceptions regarding bad faith, banks, and forgeries, the general rule remains essential. The public record is the final authority. We presume the record is correct to avoid endless litigation. Without the Mirror Doctrine, as the courts have said, the system would be useless. If the title is clean and you are an honest buyer, the law will protect you, even against the original owner in some cases.
And my takeaway is that the law protects only the vigilant. Good faith is not a visible fact like a signature. It is a state of mind manifested by acts. The Mirror Doctrine shatters if there are suspicious circumstances, whether that's occupants, a lis pendens, or simply the higher standard expected of banks. You must look at the land, not just the paper. The earth is a universal manuscript, and you have a duty to read it.
It is a complex balance. The tension between the certainty of title and the fairness of conduct is exactly what makes property law so difficult, yet so incredibly important.
Absolutely. And if there is one piece of advice to take away from this discussion, it's this. Verify the possession of any land you intend to buy. Regardless of how clean that title looks in your hand, go count the coconut trees and find out who planted them.
And while you're at it, maybe stop by the registry and check the daybook, just to be safe. It's always better to be paranoid before the sale than heartbroken after the court ruling. That's all for this edition of The Debate.
Thanks for listening.
Discuss the essence and purpose of registration of deeds or instruments, particularly of those involving lands registered under the Torrens system.
Registration is merely a species of notice. It is a ministerial act by which an instrument is sought to be inscribed in the records of the office of the Register of Deeds and annotated at the back of the certificate of title covering the land subject of the instrument. It is not a declaration by the state that such an instrument is a valid and subsisting interest in the land. The law on registration does not require that only valid instruments shall be registered. The purpose of registration is merely to give notice.
What is meant by the rule that registration of deeds or instruments must be done with the proper registry?
Registration of instruments must be done in the proper registry in order to effect and bind the land. Prior to the Property Registration Decree of 1978, Act Number 496 or the Land Registration Act governed the recording of transactions involving registered land, that is, land with a Torrens title. On the other hand, Act Number 3344 as amended provided for the system of recording of transactions over unregistered real estate without prejudice to a third party with a better right. Accordingly, if a parcel of land covered by a Torrens title is sold, but the sale is registered under Act Number 3344 and not under the Land Registration Act, the sale is not considered registered, and the registration of the deed does not operate as constructive notice to the whole world. The Supreme Court has already ruled that the registration contemplated in this provision refers to registration under the Torrens system, which considers the act of registration as the operative act that gives validity to the transfer or creates a lien upon the land. This rule precisely applies to cases involving conflicting rights over registered property and those of innocent transferees who relied on the clean title of the property. Thus, we held that registration must be done in the proper registry in order to bind the land. Thus, there was no valid registration where it is uncontroverted that the subject property was under the operation of the Torrens system even before the respective conveyances to the transferees were made, and the transferees knew of this and admit this as a fact. Yet, despite this knowledge, the transferees registered the sale in its favor under Act 3344 on the contention that at the time of sale there was no title on file. In this case, since the extrajudicial partition of real estate with deed of absolute sale in favor of Asnar as transferee was registered under Act 3344 and not under Act 496, the said document is deemed not registered at all. Rather, it was the sale in favor of Go Kim Chuan, which was registered under Act number 496 that bound the land. Act 3344 provides for the system of recording of transactions or claims over unregistered real estate without prejudice to a third party with a better right. But if the land is registered under the Land Registration Act and therefore has a Torrens title, and it is sold and the sale is registered not under the Land Registration Act but under Act 3344 as amended, such sale is not considered registered as the term is used under Article 1544 of the New Civil Code.
Is the execution of a deed of sale absolutely necessary for validity of the transaction involving sale of registered land, and what function does it actually serve in the transfer of ownership and title to the buyer?
The recording of the sale with the proper registry of deeds and the transfer of the certificate of title in the name of the buyer are necessary only to bind third parties to the transfer of ownership. As between the seller and the buyer, the transfer of ownership takes effect upon the execution of a public instrument conveying the real estate, registration of the sale with the registry of deeds, or the issuance of a new certificate of title does not confer ownership on the buyer. Such registration or issuance of a new certificate of title is not one of the modes of acquiring ownership. In sum, although the execution of a deed of sale is absolutely unnecessary for validity, it is nevertheless important for 1. The enforceability of executory contracts under Article 1403 of the Civil Code. 2. The convenience of the parties under Article 1358 of the same code. And 3. The eventual registration of the sale with the Land Registration Authority under Presidential Decree number 1529. It is also equivalent to the delivery of the ownership of the thing if from the deed the contrary does not appear. However, in Rojas versus Dinglasan, the Supreme Court expressed the same ideas in slightly different language. Here, the complaint in intervention was to vindicate ownership of the land in the intervenors. The deeds of sale involving the land covered by the Certificate of Title 9125 in the name of the vendor Pelisa Calao not having been registered, the said intervenors did not acquire ownership of the land. It is well settled according to the court in this case that in case of sale of a piece of land titled under the Torrens System, it is the act of registration and not tradition that transfers the ownership of the land sold. The bendees intervenors, not having acquired the ownership of the land, their action to vindicate ownership must fail, because such action can prosper only upon proof by plaintiff that he is the owner. As pointed out, the intervenors did not acquire ownership of the land because their deeds of sale were not registered. Registration is the operative act that gives validity to the transfer or creates a lien upon the land. All persons dealing with property covered by a Torrens certificate of title are not required to go beyond what appears on the face of the title. This was what the Supreme Court said in Philippine National Bank versus Intermediate Appellate Court.
Discuss the legal effect of registration under sections 51 and 52 of P.D. numbered 15 to 9, or the Property Registration Decree.
Under the provisions of sections 51 and 52 of the Property Registration Decree, the act of registration is the operative act to convey or affect the land. Insofar as third persons are concerned, constructive notice is also created upon registration of every conveyance, mortgage, lease, lien, attachment, order, judgment, instrument, or entry affecting the registered land. According to Gatyawan versus Gafud, under the rule of notice, it is presumed that the purchaser has examined every instrument of record affecting the title. Such presumption is irrebuttable. He is charged with notice of every fact shown by the record and is presumed to know every fact which an examination of the record would have disclosed. This presumption cannot be overcome by proof of innocence or good faith. Otherwise, the very purpose and object of the law requiring a record would be destroyed. Such presumption cannot be defeated by proof of want of knowledge of what the record contains any more than one may be permitted to show that he was ignorant of the provisions of the law. The rule that all persons must take notice of facts which the public record contains is the rule of law. The rule must be absolute. Any variation would lead to endless confusion and useless litigation. In Gatyawan versus Gapud, it was asked, may the purchaser of the land which has been included in a second original certificate ever be regarded as an innocent purchaser, as against the rights or interests of the owner of the first original certificate, his heirs, assigns, or bendi? The first original certificate is recorded in the public registry. It is never issued until it is recorded. The record is noticed to all the world. All persons are charged with the knowledge of what it contains. All persons dealing with the land so recorded or any portion of it must be charged with notice of whatever it contains. The purchaser is charged with notice of every fact shown by the record and is presumed to know every fact which the record discloses. This rule is so well established that it is scarcely necessary to cite authorities in its support. So, in view of the foregoing rules of law, may the purchaser of land from the owner of the second original certificate be an innocent purchaser when a part or all of such land had theretofore been registered in the name of another, not the vendor. We are of the opinion, according to the Supreme Court, that said sections 38, 55, and 112 should not be applied to such purchasers. We do not believe, according to the Supreme Court, that the phrase innocent purchaser should be applied to such a purchaser. He cannot be regarded as an innocent purchaser because of the facts contained in the record of the first original certificate. The rule should not be applied to a purchaser of a parcel of land, the vendor of which is not the owner of the original certificate or his successors. He in no sense could be regarded as an innocent purchaser of the portion of the land included in another earlier certificate. The rule of notice of what the record contains precludes the idea of innocence. By reason of the prior registry, there cannot be an innocent purchaser of land included in a prior original certificate and in a name other than that of the vendor or his successors. In order to minimize the difficulties, we think, according to the Supreme Court, that this is the safer rule to establish.
Distinguish between voluntary and involuntary dealings involving registered lands, particularly in terms of the requirements for their registration.
A voluntary instrument is a willful act of the registered owner of the land to be affected by registration, while an involuntary instrument is one pertaining to a transaction affecting lands in which the registered owner's cooperation is not needed and which transaction may even be done against his will. For the registration of a voluntary instrument, it is necessary not only to register the deed, instrument, or assignment, mortgage, or lease in the entry book of the Register of Deeds, but a memorandum thereof must also be made on the owner's duplicate and on its original. The mere entry by the Register of Deeds in the entry or diary book without the presentation of the owner's duplicate certificate of title or corresponding annotation of the conveyance does not have the effect of a conveyance of the property. On the other hand, for the registration of an involuntary instrument, the law does not require the presentation of the owner's duplicate certificate of title and considers the annotation of such instrument upon the entry book as sufficient to affect the real estate to which it relates. The reason for the difference is obvious. In a voluntary instrument, the registered owner of the land to be affected by registration is presumed to be interested in registering the instrument and would willingly surrender, present, or produce his duplicate certificate of title to the Register of Deeds in order to accomplish such registration. On the other hand, as the registration of an involuntary instrument is contrary to the interest of the registered owner or will affect him adversely, it is but natural that he will not willingly present or produce his duplicate certificate or at least delay the production as long as possible.
For purposes of registering voluntary transactions involving registered lands held under co-ownership, is it necessary for all co-owners duplicate certificates of title to be surrendered to the Register of Deeds in order to authorize such registration?
In Balbin versus Register of Deeds of Ilocos Sur, the Supreme Court found no merit in the petitioner's contention that they were not obligated as co-owners to surrender all the co-owners' duplicate certificate of title for purposes of registering a voluntary transaction involving land that is co-owned. Section 55 obviously assumes that there is only one duplicate copy of the title in question, namely that of the registered owner himself, such that its production whenever a voluntary instrument is presented constitutes sufficient authority from him for the Register of Deeds to make the corresponding memorandum of registration. In this case, however, the three other copies of the title were in existence, presumably issued under Section 43 of Act Number 496. As correctly observed by the Land Registration Commission, petitioners claim that the issuance of those copies was unauthorized or illegal is beside the point, its legality being presumed until otherwise declared by a court of competent jurisdiction. There being several copies of the same title in existence, it is easy to see how their integrity may be adversely affected if an encumbrance or an outright conveyance is annotated on one copy and not on the other. The law itself refers to every copy authorized to be issued as a duplicate of the original, which means that both must contain identical entries of the transaction, particularly voluntary ones affecting the land over by the title. If these were not so, if different copies were permitted to carry differing annotation, the whole system of Torrens registration would cease to be reliable.
Explain the so-called Mirror Doctrine, which is one of the generally accepted principles underlying the Torrens System of Registration.
The operative act that binds the land is registration by the owner. If the deed is not registered, it is binding only between the parties. The general rule is that, and this has come to be known as the Mirror Doctrine, where there is nothing on the certificate of title to indicate any cloud or vice in the ownership of the property or any encumbrance thereon, the purchaser is not required to explore further than what Torrens title upon its face indicates, in quest for any hidden defect or inchoate right that may defeat his rights thereto. Under the Torrens system, according to Justice Regala, registration is the operative act that gives validity to the transfer or creates a lien upon the land, citing sections 50 and 51 of the Land Registration Act. Consequently, where there was nothing in the certificate of title to indicate any cloud or vice in the ownership of the property or any encumbrance thereon, the purchaser is not required to explore further than what the Torrens title upon its face indicates, in quest for any hidden defect or inchoate right that may subsequently defeat his right thereto. If the rule were otherwise, the efficacy and conclusiveness of the certificate of title which the Torrens system seeks to ensure would entirely be futile and nugatory.
Discuss, with appropriate illustration, the chain of title doctrine.
Every person dealing with registered land may safely rely on the correctness of the certificate of title issued therefore, even if a decree in a registration proceeding is infected with nullity. Still, an innocent purchaser for value relying upon a Torrens title issued in pursuance thereof is protected. This according to the case of Cruz versus Court of Appeals and Susara. And although generally a forged or fraudulent deed is a nullity and conveys no title, however, there are instances where such a fraudulent document may become the root of a valid title. One such instance is where the certificate of title was already transferred from the name of the true owner to the forger, and while it remained that way, the land was subsequently sold to an innocent purchaser for value. Justice Regala, speaking for the Supreme Court in Fule versus Delegare, explained, although the deed of sale in favor of John Delegare was fraudulent, the fact remains that he was able to secure a registered title to the house and lot. It was this title which is subsequently conveyed to the herein petitioners. We have indeed ruled that a forged or fraudulent deed is a nullity and conveys no title. However, we have also laid down the doctrine that there are instances when such a fraudulent document may become the root of a valid title. One such instance is where the certificate of title was already transferred from the name of the true owner to the forger, and while it remained that way, the land was subsequently sold to an innocent purchaser for value. For then, the vendee had the right to rely upon what appeared in the certificate of title. Justice Regala further explained in Fule versus Delegare that the Supreme Court has been constrained to adopt the conclusion here set forth because under the Torrens system, registration is the operative act that gives validity to the transfer or creates a lien upon the land. Where there was nothing in the certificate of title to indicate any cloud or vice in the ownership of the property or any encumbrance thereon, the purchaser is not required to explore further than what the Torrens title upon its face indicates, in quest for any hidden defect or inchoate right that may subsequently defeat his right thereto. If the rule were otherwise, the efficacy and conclusiveness of the certificate of title which the Torrens system seeks to ensure would entirely be futile and nugatory. The public shall then be denied of its foremost motivation for respecting and observing the Land Registration Act. In the end, the business community stands to be inconvenienced and prejudiced immeasurably.
Who is an innocent purchaser for value?
A purchaser in good faith and for value is one who buys the property of another without notice that some other person has right to or an interest in such property, and who pays a full and fair price for the same at the time of such purchase or before he or she has notice of the claims or interest of some other person. Good faith is the honest intention to abstain from taking any unconscientious advantage of another. In Rojas versus Dinglasan, the Supreme Court also had the occasion to address the case of an innocent mortgagee for value. In this case, it stated, the next question before us is whether the mortgage was valid. Article 2085 of the new Civil Code requires that the mortgagor be the owner of the property mortgage. Although Pedro Dinglasan was not the owner of the property mortgage because he had secured title thereto through fraud or falsification of a public document, the mortgage was valid because Leonora T. Rojas was an innocent mortgagee for value, having relied upon the mortgagor's transfer certificate of title, which according to the Register of Deeds was genuine and free from any objection. In the case of De Lara et al. Versus Irosa, the Supreme Court held that where the certificate of title was already in the name of the forger when the land was sold to an innocent purchaser, the vendee had the right to rely on what appeared in the certificate, and in the absence of anything to excite suspicion, was under no obligation to look beyond the certificate and investigate the title of the vendor appearing on the face of said certificate. In Rural Bank of Sariaya versus Yakun, the Supreme Court declared that the rule applicable to the controversy therein involved, with the exception thereto, is well settled, where the certificate of title is in the name of the mortgagor when the land is mortgaged. The innocent mortgagee for value has the right to rely on what appears on the certificate of title. In the absence of anything to excite or arouse suspicion, said mortgagee is under no obligation to look beyond the certificate and investigate the title of the mortgagor appearing on the face of the said certificate. Although Article 2085 of the Civil Code provides that absolute ownership of the mortgage property by the mortgagor is essential, the subsequent declaration of a title as null and void is not a ground for nullifying the mortgage right of a mortgagee in good faith. In Philippine National Bank versus Intermediate Appellate Court, the Supreme Court made the following observations. The case at bar does not in any way fall within the exceptions mentioned above. In fact, it is the general rule which applies. Every registered owner receiving a certificate of title in pursuance of a decree of registration, and every subsequent purchaser of registered land taking a certificate of title for value and in good faith shall hold the same free from all encumbrances not noted on the title. When transfer certificates of titles were issued in favor of the transferees, the donees, and the purchaser, nothing was said therein about the land having been reserved for a public open space. Persons dealing with a property covered by a Torrens certificate of title are not required to go beyond what appears on the face of the title. When there is nothing on the face of the title to indicate any cloud or vice in the ownership of the property or any encumbrance thereon, the purchaser is not required to explore further than what the Torrens title upon its face indicates in quest for any hidden defect or inchoate right that may subsequently defeat his right thereto. Thus, a bank is not required before accepting a mortgage to make a detailed investigation of the history of the title of the property being given as security, and where innocent third persons like the mortgages relying on the certificate of title acquire rights over the property, their rights cannot be disregarded.
Who carries the burden of proving the status of an innocent purchaser for value?
Initially, the burden of proving the status of a purchaser in good faith lies upon the one who asserts that status, and his onus probandi cannot be discharged by mere invocation of the legal presumption of good faith, even if there is no allegation in the complaint against the buyers that the subject property was purchased in bad faith, if their answer evince otherwise, as when they asserted that they were transferees, buyers in good faith. The onus probandi is upon them. The buyers would do well to remember that in civil cases, the specific rule as to the burden of proof is that the plaintiffs have the burden of proving the material allegations of the complaint which are denied by the answer, and defendants have the burden of proving the material allegations in their answer which sets up a new matter as a defense. It should be mentioned that this rule does not involve a shifting of the burden of proof, but merely that each party must establish his or her own case.
Discuss the notion of good faith as a function of actual due diligence.
Purchasers cannot close their eyes to known facts that should put a reasonable person on guard and subsequently claim to have acted in good faith in the belief that there was no defect in the vendor's certificate of title. Their mere refusal to face up to that possibility will not make them innocent purchasers for value if it later becomes apparent that the title was indeed defective and that they would have discovered the fact had they acted with the measure of precaution required of a prudent person in similar circumstances.
How may good faith be established?
Good faith, or the lack of it, is a question of intention which could be ascertained only from the acts of one claiming its presence, for it is a condition of the mind which can be judged by actual or fancied token or signs. It is not a visible, tangible fact that can be seen or touched, but rather a state or condition of mind manifested by the acts of the individual concerned. Good faith being a state of mind, only the purchasers themselves could personally attest as to how they observed the required diligence in the purchase of real property. Where there were several buyers involved, the testimony alone of one buyer is insufficient to establish that all of the other buyers were equally purchasers in good faith. More so where the offer of said buyer's testimony merely covered her own alleged status as a purchaser in good faith and for value. Without evidence to establish good faith, the court would find that other buyers have failed to discharge the burden of proving that they were innocent purchasers for value.
When may the burden of proving good faith be discharged by proof of reliance upon what appears within the four corners of a certificate of title?
Concomitantly as to the testifying buyer's status as an innocent purchaser for value of a registered and titled land, she need only show that she relied on the face of the title to the property of their seller without further inquiry beyond the four corners thereof. Nevertheless, this degree of proof of good faith is only sufficient when the following conditions concur. First, the seller is the registered owner of the land. Second, the seller is in possession thereof. And third, at the time of the sale, the buyer was not aware of any claim or interest of some other person in the property or of any defect or restriction in the title of the seller or in his capacity to convey title to the property. So, even if the subject property was registered to the sellers, if there were circumstances which would have impelled a reasonably cautious man to make an inquiry into the status of the title of the property in litigation, then it is no longer sufficient for the buyer to merely show that she relied on the face of the title, as she must also now substantiate that she exercised reasonable precaution by inquiring beyond the title.
Discuss how banks or financial institutions may be accepted from the general rule that good faith may be shown by reliance upon what appears within the four corners of a certificate of title.
Where, however, the purchaser or mortgagee is a bank or financing institution, the general rule that the purchaser or mortgagee of the land is not required to look further than what appears on the face of the title does not apply. In Rural Bank of Sariaya versus Yakun, the Supreme Court stated there is no ground to reject or deviate from the findings of both the trial court and the Court of Appeals. In cases heretofore decided by this court, we took judicial notice of the common practice of banks before approving a loan to send a representative to the premises of the land offered as collateral and duly investigate who are the true owners thereof. Failure to do so was considered as constitutive of negligence on the part of the banks. This is in keeping with the bank's responsibility to exercise care and prudence in dealing even with registered land, more than in the case of private individuals. The bank's business is affected with public interest, keeping in trust money belonging to their depositors, which they should guard against loss by not committing any act of negligence which amount to lack of good faith, by which they would be denied the protective mantle of the Land Registration Statute, Act Number 496, now PD 1529, extended only to purchasers for value and in good faith, as well as to mortgages of the same character and description. The finding that the petitioner bank failed to make adequate inquiries with the person in possession of the land had adequate evidentiary support. The testimony of the bank inspector, Ricardo Aro Jr., that he went to the land together with an assistant inspector does not bespeak the diligent verification required in the circumstances. As earlier stated, the prudent practice is to investigate who are the true owners of the properties sought to be mortgaged. What appears to have been done in the present case is that the petitioner merely went through the motions of sending a representative to the premises. When the inspector found nobody on the land on the date of inspection, he only counted the coconut trees without bothering to look for the person in possession of the same. He further testified that he did not bother to find out who was in actual possession of the property when he went to the premises, relying on the fact that the vice president of the bank had already talked to Luis Parco, the mortgagor. Petitioner is therefore not in a position to assail the finding that Luis Parco never took possession of the land in question, and that the respondents continuously and openly possessed the land without any disturbance. When the purchaser or mortgagee is a financing institution, the general rule that a purchaser or mortgagee of land is not required to look further than what appears on the face of the title does not apply. The constructive knowledge of the financial institution of the defect in the title of the subject property, or the lack of such knowledge due to its negligence, takes the place of registration.
Discuss illustrative cases or instances where the purchaser or mortgagee may be deemed to have acted in bad faith.
We now discuss a number of instances where the purchaser may be deemed in bad faith, starting with the case of Egao versus Court of Appeals. According to the case of Egao versus Court of Appeals, where a purchaser neglects to make the necessary inquiries and closes his eyes to the facts which should put a reasonable man on his guard as to the possibility of the existence of a defect in his vendor's title, and relying on the belief that there was no defect in the title of the vendor, purchases the property without making any further investigation, he cannot claim that he is a purchaser in good faith and for value. Egao versus Court of Appeals further explains that the law requires a higher degree of prudence from one who buys from a person who is not the registered owner when the land object of the transaction is registered land, while one who buys from a registered owner need not look behind the certificate of title. One who buys from another who is not the registered owner is expected instructed to examine not only the certificate of title but all factual circumstances necessary for him to determine if there are any flaws in the title of the transferor or in his capacity to transfer the land. Failing to exercise caution of any kind whatsoever is tantamount to bad faith. In Bergado versus Court of Appeals, it was held that the inscription of an escritura de compraventa in 1964 produced no legal effect because it was made in bad faith. Ownership should therefore vest in the respondent Republic of the Philippines because it was the first in possession of the property in good faith. If any recourse is still available to the petitioners, it definitely is not against the Republic of the Philippines. Their claim for satisfaction, on which we do not rule at this time, may be addressed only to Marciana Trinidad, who, for reasons still to be discovered, sold the same land once and then once again to separate purchasers. Where a person buys land not from the registered owner but from one whose rights to the land has been merely annotated on the certificate of title, he could be considered a buyer in bad faith. Where the buyer in question bought the property from Natividad Escarilla, who in turn acquired it from Salvador Solano. The different deeds of conveyance were merely annotated on the original and duplicate certificates of titles which appear in the name of the previous owners. Neither Solano nor Escarilla nor Mirasol ever secured from the Register of Deeds transfer of a new certificate of title in their names. In other words, the only picture Mirasol presents before us is that of a purchaser of registered land from a person who did not have any certificate of title in his name, his only evidence being the deed of sale in his favor and its annotation on the certificate of title which still appears in the name of the previous owners, most of whom have already died. He is not therefore a subsequent purchaser of registered land who takes a certificate of title for value and in good faith, and who is protected against any encumbrance except those noted on the said certificate of title. In Francisco versus Court of Appeals, the Supreme Court emphasized sufficiently strong indications to impel closer inquiry into the location, boundaries, and condition of the lot involved. Speaking for the Supreme Court in this case, Chief Justice Narbasa stated, there were, in a word, sufficiently strong indication to impel a closer scrutiny into the location, boundaries, and condition of the two smaller lots embraced in the purchase on the part of Casimiro Espirito and his co-vendis. That inquiry is in truth dictated by common sense, expected of a man of ordinary prudence. The earth, it has been said, is that universal manuscript open to the eyes of all. When a man proposes to buy or deal with realty, his first duty is to read this public manuscript, that is, to look and see who is there upon it and what are his rights. The buyer who could not have failed to know or discover that the land sold to him was in the adverse possession of another is a buyer in bad faith, such knowledge being equivalent to registration. The presence of occupants is an important consideration in determining good or bad faith on the part of the purchaser. The principle of caveat emptor simply requires the purchaser of real property to be aware of the alleged title of the vendor, such that one who buys without checking the vendor's title takes all the risk and losses consequent to such failure, while a buyer of registered land need not go beyond its certificate of title. The buyer is nonetheless obliged to investigate or inspect the property sold to him when there are circumstances that would put him on guard, such as the presence of occupants other than the registered owner. While a buyer of registered land need not go beyond its certificate of title, the buyer is obliged to investigate or inspect the property sold to him when there are circumstances that would put him on guard, such as the presence of occupants other than the registered owner. The buyer cannot claim ignorance of any defect in the vendor's title if, in neglecting to verify the nature of the occupant's possession, the latter should turn out to have a better right to the property than the registered owner. While possession by a third person other than the registered owner could indicate a defect in the title of the vendor, it does not per se render the latter's title defective. It is only when such possession is of a character that would confer upon the possessor some superior right against the registered owner that the latter may be deemed to have a flawed title. Since respondents' adverse, open, and notorious possession of the lots cannot defeat the title of Chacon Enterprises Incorporated, the former did not acquire any superior possessory rights over the lots. Petitioner thus acquired a clean title from Chacon Enterprises Incorporated and is not barred from recovering possession of the lots from the respondent. One who purchases land with a certificate of title containing a notice of lis pendens takes such land subject to the outcome of litigation and may therefore not be an innocent purchaser for value. Lis pendens is a Latin term which literally means a pending suit. Notice of lis pendens is filed for the purpose of warning all persons that the title to certain property is in litigation, and if they purchase the same, they are in danger of being bound by an adverse judgment. The notice is therefore intended to be a warning to the whole world that one who buys the property does so at his own risk. This is necessary in order to save innocent third persons from any involvement in any future litigation concerning the property. According to Justice, later Chief Justice Peralta, its notice is an announcement to the whole world that a particular property is in litigation and serves as a warning that one who acquires an interest over said property does so at his own risk, or that he gambles on the result of the litigation over said property. In Bernales versus Intermediate Appellate Court, the purchaser had full knowledge of the flaws and defects of the title and so could not have been an innocent purchaser for value. Take note of the reasoning of Justice Paras in Bernales versus Court of Appeals. He said, the kadyam spouses to whom a transfer certificate of title was issued after the purchase of the lot from Elpidio Siagan for a valuable consideration as stated in the deed, and who had no knowledge of any flaw or defect of the title at the time of the purchase, are evidently, as ruled by the Court of Appeals, innocent purchasers for value, and above all are entitled to the protection of the law. In contrast, petitioners allegedly acquired the subject property by virtue of the sale made by Constante Siagan 6 months before the execution of the Memorandum of Agreement and the other documents above mentioned. Constante Siagan, claiming to have inherited lot 14194 from his grandmother, sold said lot to Pasimio spouses, who later sold the same to the Roman Catholic Bishop of Banged Incorporated, and the latter in turn sold the same to the petitioners. But the authority of Constante Siagan to sell said lot was wanting. The ownership and possession of Dagawan Sawadan over lot 1494 were transmitted through hereditary succession to Augusto Siagan, her son, and not to Constante Siagan, her grandson. Constante cannot claim to have inherited the same in 1967 because his father, Augusto Siagan, who entered into the amicable settlement and quitclaim with Elpidio Siagan, was still living, and he died only in October 1975. Much less is there any document showing that said property was transmitted or ceded to him either by by Dagawan Sawadan or Augusto Siagan. Thus, the sale made by a non-owner, Constante Siagan, and all subsequent sales made thereunder are null and void. In Makiling versus Umadhay, the Supreme Court stated that good faith affords protection only to purchasers for value from the registered owner. Deogracias Evangelista, the defendant's grantor in this case, was not a registered owner. The land was and still is registered in the name of Casimiro Evangelista. In no way does the certificate state that Deogracias owned the land. Consequently, defendants cannot summon to their aid the theory of indefeasibility of Torrens title. There is nothing in the certificate of title and in the circumstances of the transaction which warrant them in supposing that they need not look beyond the title. If anything, it would have put them on their guard, cautioned them to ascertain and verify that the vendor was the only heir of his father, that there was no debt, and that the latter was the sole owner of the parcel of land. However, while the Umadhay spouses cannot rely on the title, the same not being in the name of their grantor, Respondent Crisanta S. Gumban stands on a different footing altogether. At the time she purchased the land, the title thereto was already in the name of her vendors. She had the right to rely on what appeared on the face of the said title. There is nothing in the record to indicate that she knew of any unregistered claims or equities in the land pertaining to other persons, such as that of hearing petitioner, or of any other circumstances which should put her on guard and cause her to inquire behind the certificate. According to the Court of Appeals, she took all the necessary precautions to ascertain the true ownership of the property, having engaged the services of a lawyer for the specific purpose, and it was only after said counsel had assured her that everything was in order did she make the final arrangement to purchase the property. The appellee court's conclusion that Respondent Crisanta S. Gumban was a purchaser in good faith and for value is correct, and the title she has thereby acquired is good and indefeasible.
Discuss why the status of an innocent purchaser for value may not be claimed by a person who dealt with an impostor, while the certificate of title remains registered in the name of the true owner.
The ruling in Fule versus Delegare cannot be applied where the owner still holds a valid and existing certificate of title covering the same property, because the law protects the lawful holder of a registered title over the transfer of a vendor bereft of any transmissible right. In one case, the Supreme Court, through Justice Pacifico de Castro, declared that indeed it found more weight and vigor in a doctrine which recognizes a better right for the innocent original registered owner who obtained the certificate of title through perfectly legal and regular proceedings than one who obtains his certificate from a totally void one, as to prevail over judicial pronouncements to the effect that one dealing with registered land, such as a purchaser, is under no obligation to look beyond the certificate of title of the vendor, for in the latter case, good faith has yet to be established by the vendee or transferee, being the most essential condition, coupled with valuable consideration to entitle him to respect for his newly acquired title, even as against the holder of an earlier and perfectly valid title. Continuing with his reasoning, Justice Pacifico de Castro further stated that there might be circumstances apparent on the face of the certificate of title which could excite suspicion as to prompt inquiry, such as when the transfer is not by virtue of a voluntary act of the original registered owner, as in this case, where it was by means of a self-executed deed of extrajudicial settlement, a fact which should be noted on the face of Eusebia Tomas' certificate of title. Failing to make such inquiry would hardly be consistent with any pretense of good faith, which the appellant bank invokes to claim the right to be protected as a mortgagee.
Discuss the rule for resolving a case of double sale made possible by the issuance of two certificates of title covering the same piece of registered land issued successively in the name of the same person.
The case of DVP versus Mangawang involves quite a different situation. In this case, there is no doubt, according to the court, that if two original certificates of titles were issued on different occasions to two different persons, the contention of appellees would be correct, it being in line with several decisions rendered by the Supreme Court. But the case at bar is different. Here, two different certificates of titles were issued to Gabino Amposta over the same parcel of land, one under the Homestead Law and another under the Cadastral Act. Said titles were regularly issued and on their face, both appear to be valid, and under such predicament, it behooves Amposta to choose which of them he would prefer, as he could not validly make use of both of them. But this Amposta did not do. On the contrary, he took advantage of the situation by selling the land to two different persons, surrendering to each purchaser the pertinent certificate of title. The question then that arises is, who of the two buyers should be considered as the rightful owner of the land? On this score, it is important to consider the facts that led to the sale of the land to the parties herein. Note that Amposta first sold the land to Santos Camacho on November 24, 1941, who registered it in his name on the same date. And 7 years later, or on March 17, 1948, Amposta again sold the land to the Mangawang brothers, who also registered it in their name on the same date. Since both purchasers apparently have acted in good faith, as there is nothing in the evidence to show that they did otherwise, we cannot but conclude that the sale made by Amposta to Santos Camacho is the valid one, considering that when Amposta sold the same land to the Mangawang brothers, he had nothing more to sell, even if the title he surrendered to them is one issued covering the same property. In legal contemplation, therefore, Amposta sold a property he no longer owned, and hence the transaction is legally ineffective. On the other hand, the case under consideration can also be viewed under a different angle. It can also be treated as one of double sale, where a person sells the same land to two or more different persons who are unaware of the flaw that lies in its title, and where the law adjudicates the property to the purchaser, who first registers the transaction in his name in the registry of property. And applying this principle, we cannot but conclude that the title should likewise be adjudicated to appellant whose predecessor in interest acquired and registered the property much ahead in point of time than the appellees. Verily, the title acquired by the latter is invalid and ineffective, contrary to the finding of the court ako.